We've got a lot to talk about, so.
Whether you're not sitting.
Hello, everyone. Let me welcome you, and we'll go ahead and get started. Is the Zoom feed live? Can somebody confirm the Zoom feed is live? It is live? Okay, great. Wonderful. We'll go ahead and get started today. Welcome to part 2 of Let's Talk and Let's Listen. So grateful to welcome everyone here. My name is Keith Call, and I'll have the privilege of moderating this event today. For everyone's information, I'd like to let you know that for the live audience, we have 850 people registered to be present on Zoom. So a really outstanding response and a lot of interest. And for those of you on Zoom, we have approximately 50 people here in our live audience at the Utah Law and Justice Center, including many distinguished guests. And we're so grateful to each of you for being here. We welcome you and welcome your attendance here today. I would like to begin today by expressing a special thanks to our event sponsors, Spencer Fane and Snell and Wilmer. A special shout out to Stuart Pay and Wade Budge, who have helped make this event possible. We're very grateful for all of your support. I also want to express thanks to the Utah Bar, especially Michelle Oldroyd, Elizabeth Wright, and all of the staff at the Utah Bar who've made this event what it is. Let's get into it by introducing our panelists today. So grateful to have 2 panelists with us today. First, I will introduce Utah Supreme Court Justice Paige Petersen. Justice Petersen began her post-high school education by earning an associate's degree from the College of Eastern Utah. Go Eagles! She then graduated with a bachelor's degree from the University of Utah. Go Utes! And then she earned her law degree from Yale Law School in 1999. Go Bulldogs! In terms of her legal career, she clerked for 2 years with the U.S. District Court for the Southern District of Ohio. She then joined as a litigation associate the firm of Simpson, Thatcher, and Bartlett in New York City. She then transitioned to criminal law, working as an assistant U.S. attorney in the Eastern District of New York, followed by a stint prosecuting war crimes at the International Criminal Tribunal for the former Yugoslavia in The Hague, Netherlands. What an amazing experience that is. And she then returned to Utah, joined the U.S. Attorney's Office in Salt Lake City, where she prosecuted violent crimes for 3 years before taking the bench as a 3rd District Court judge, and was then appointed to the Utah Supreme Court in December 2017 by Governor Gary Herbert. Thank you, Justice Paige Petersen, for being here today. I also want to introduce Mr. Ron Gordon. Mr. Gordon serves as the court administrator for the Utah Administrative Office of the Courts. He graduated with a Bachelor of Science degree from BYU in 1995. Go Cougars! We're hitting them all today. He received his law degree from the University of Utah in 1998. He has served as a coordinator for the Salt Lake County Justice Advisory Council, director of the Utah Sentencing Commission, executive director of the Utah Commission on Criminal and Juvenile Justice, and as general counsel for Governor Gary Herbert. He was appointed as the Utah Court Administrator in 2021 by Chief Justice Matthew B. Durant. So to begin, Mr. Gordon, perhaps you could tell us, what does the court administrator do?
Excellent. I get asked that question a lot. By statute, the court administrator is responsible for overseeing all of the administrative aspects of the judiciary. So there's one thing about which I need to be very clear. I don't tell judges what to do. I am not the boss of any judge. I have nothing to do with the actual decision-making because that is entirely up to the judges. But as you might imagine, there's a lot of work that goes into supporting the work, administrative work of the judiciary. I oversee all of that, and I'm the primary staff person to the Utah Judicial Council, which is one of the two governing bodies established by the state constitution. The other, of course, is the Utah Supreme Court.
Thank you very much. So let me set the stage for today's discussion. The fact that we have so many people in attendance today, in person and via Zoom, testifies to the fact that lawyers and judges have a profound interest in what is happening with the judicial and legislative branches in our state. This past legislative session featured an unprecedented number of bills that directly and indirectly impact the judiciary and the legal profession. One gets the idea that our legislators, who are ultimately elected by the people, are a bit fed up with the courts and what has been happening at the courts. But the courts and the legal profession have not been standing idly by. By my unofficial count, the Utah Bar Association opposed at least 23 legislative bills this last session. We saw lobbying groups pop up, soliciting members of the bar to contact their legislators and donate money. Lawyers have spoken out on social media and other platforms about the importance of public confidence in our courts. And in his State of the Judiciary speech, Chief Justice Matthew Durant pleaded for civility and a presumption of good faith by our legislators. Now, our goal today is to have a meaningful dialogue about these balance of power, check and balance issues. I hope we can get beyond catchphrases and headliners and help all of us gain a better understanding of our judicial leaders' views on these critical issues and the appropriate balance of power between the branches of government. Now, I have just a couple of slides to kind of set the stage. Way too many words, I know that, but these are not meant to be read. This is meant to give you a visual impact. This first slide is my unofficial, Keith Call solely responsible for gathering this information, of bills that passed the legislature this year impacting the courts and the judiciary. And this slide shows a number of bills and resolutions that were introduced but did not pass. And again, I don't expect you to read this or understand all of these, but I hope that visual impact means something to you. So, Justice Petersen, I'd like to begin with you, and I'd like to take you back to an event that preceded the flurry of legislation that we have seen this last session, and legislation aimed at the judiciary and seemed to an event that seemed to inflame the legislature's frustration with the courts. As you know, in the summer of 2024, the Utah Supreme Court published an opinion in the case of League of Women Voters of Utah versus Utah State Legislature. That's the redistricting case, for those of you who don't recognize the name. On the same day that opinion was issued, the Utah Speaker of the House and the Senate President issued a statement saying in part, quote, "This is one of the worst outcomes we've ever seen from the Utah Supreme Court," close quote. Then last year, in a special session in December 2025, the legislature passed House Joint Resolution 201, which condemned the Utah Supreme Court for its opinion in the same case, calling it an, quote, "activist rewriting of the Utah Constitution," close quote. So Justice Petersen, what is your response or your reaction to this activity by the legislature and all of the legislation that followed?
Okay, so we're starting with a bang. I know that some members of the legislature have been very angry about that opinion, and I heard the criticism. It's been called an activist opinion. There's been the criticism that we somehow created super laws in this opinion. And look, I think criticism is fair game when you take a position, a public position. I know that I will get criticism. My colleagues know we will get criticism, and I'm always open to hearing criticism. But I wish the criticism in this specific instance were more directed at the legal issues we actually answered. I think that, you know, we issue our opinion and then we stay silent. Judges don't comment about things, dialogue that's going on out in the public much. And so we just hear the debate that's going on, and a lot of it isn't really focused on what we actually said in the opinion. So if I can ask you to be patient for a minute, I would love to just briefly summarize what we actually held, because that's what this debate should focus on. So as you all know, I'm sitting here with a group of lawyers in the audience. Lawyers are watching. We all know the role of the judiciary. One of our main roles is what's called judicial review. All the branches of government take an oath to uphold the Constitution, and we do it in different ways. The way that the judiciary does it is that we are charged with interpreting the Constitution, both our state constitution and the federal constitution, and applying it in specific cases. We don't create the law. We look at the law as it exists, we interpret it, and we apply it in controversies that are brought before us. And that's what we did in this case. The question that was presented for us was by sponsors of a citizen initiative and some voters and some other non-political groups who brought a case about Proposition 4, which was a citizen initiative that prohibited partisan gerrymandering in redistricting. And they were challenging the fact that after that initiative was passed, it was enacted by the voters of the state, the legislature repealed that initiative. They replaced it with a law that did not ban partisan gerrymandering. And then they enacted a congressional map in 2021 that the plaintiffs said was partisan gerrymandering. So they brought their lawsuit to court. And they said that when the legislature did this, they violated two provisions of the Utah Constitution. One is the initiative power. So in Utah, citizens have legislative power. We are one of the states that has an initiative power in our Constitution that allows the people of Utah, to exercise legislative power by passing an initiative. You have to vote you have to get it onto the ballot, and then you vote at the ballot box. And if people vote in favor, you've passed a law. The citizens of Utah can pass a law. We did not create initiatives on the Utah Supreme Court. We are not the ones who came up with this. Initiatives have been in our state constitution since 1900 for 126 years. So if some of the criticism of the opinion has been that we're creating direct democracy, that we're going to lose our representative democracy, and if we allow citizens to pass initiatives, we will be overrun with direct democracy and it will impact our representative democracy. And to that, I would say, take that up with the voters of 1900, because they're the ones who put this in the Constitution. Our job is to just interpret what is there. The second provision of the Utah Constitution that was at issue is one that hadn't been talked about as much, but is in our Declaration of Rights, which is like the federal Bill of Rights. The Utah State Constitution has a Declaration of Rights. And Article 1, that's Article 1 of our Constitution, is our Declaration of Rights. In Section 2 of that, we have a provision that says this, and I'm reading from this very controversial opinion right now, so I want to get it right. I don't want to say anything that diverges from the opinion, but Article 1, Section 2 says this: all political power is inherent in the people, and all free governments are founded on their authority for their equal protection and benefit. And they have the right to alter or reform their government as the public welfare may require. That is in our Declaration of Rights of the Utah Constitution. And the plaintiffs in this case said, our initiative was aimed at reforming the government. The initiative exercised the people's right to alter or reform their government as the public welfare may require. And so when the legislature repealed it, they violated the people's right to alter or reform the government. That was their argument. The legislature's response was, when an initiative passes, it's a statute. And the legislative power that we wield allows us to amend, repeal, or enact any statute. And so this Article 1, Section 2 is not a right that you can come to court and get enforced, because our legislative power allows us to repeal any citizen initiative that is enacted, even if it reforms the government. So this is not a cognizable claim. And it had been dismissed in the district court for that reason. The legislature can repeal statutes. A citizen initiative, if successful as a statute, they can repeal it. That was the question before us. Is this an enforceable right? Does this right get constitutional protection? Or is it the case that the legislature can repeal any citizen initiative without limitation, even if it reforms the government, because they have legislative power, which allows them to do that? And what we said is, this is in our Declaration of Rights. It says what it says. It is an enforceable right. If the people of Utah think that the legislature has violated it, they can come to court and get a hearing on that. And this is a cognizable claim that you can bring to court. That is what we held. I don't think that creates a super law. This is not anything new. We know that the legislative power, while the legislature they are the final word on policy, but they too are bounded by the Constitution. So laws cannot, without limitation, do things that are beyond the bounds of the Constitution, and they cannot infringe on the exercise of fundamental constitutional rights. And so we said, this is a right that gets constitutional protection. If a law infringes that right, it is subject to constitutional scrutiny. So it would mean that it would have to be, the law would have to be meeting a compelling state interest and narrowly tailored toward that. So they can still be amended, but it has to be, if it's impairing the right, impairing the reform that the people wanted, it has to be narrowly tailored to a compelling state purpose. So that's what we held. I would love for the debate to focus on that.
Thank you for that wonderful explanation. Most of us have not read that in the headlines.
No,
And
it would be a long headline, to be fair.
that was a wonderful explanation. I really appreciate that. Mr. Gordon, perhaps we could turn to you. Is there a bill or two up here, or one that I missed that didn't make the chart from this last legislative session that you would like to discuss and talk about the impacts on the courts or the judiciary?
Sure. Happy to. I think many of you have heard about Senate Bill 134. That's the bill that added new judges. That's historic. 7 new judges were added through that bill. 2 members of the Supreme Court, 2 additional justices. That's not something that the judiciary requested. It is prerogative that the legislature has. We did ask for district court judges, juvenile court judges, court of appeals judges, and so we're thrilled to see that in addition to those 2 justices on the Supreme Court, we will receive 2 members of the Court of Appeals, which is very much needed, and 3 district court judges, a district court judge in the 3rd, 4th, and 5th districts, all of which we requested. So those all come with staff members as well. That's historic. That's great. I think that the Chief Justice's words were heard when he delivered his State of the Judiciary and said, if you're going to add members to the Supreme Court, please don't do so at the expense of the areas where our needs are great, trial court and court of appeals. So very, very happy to see that. There are some other bills that we are in the process of implementing now that will have really significant impacts. The bill about which I'm sure many of you have read that creates a new process for examining some constitutional claims, some claims involving state actors. This will create the possibility of having 3 judge panels. That'll have a significant impact on the administration of the judiciary. It'll have a significant impact on judicial resources. Now, those cases that previously involved 1 district court judge will involve 3 district court judges and staff. We are in the process of implementing that. We're in the process of implementing the process of how those judges are selected. 4 panels have already been selected and are moving forward, and there are some serious issues being debated by those panels, some serious constitutional issues. There are some other bills maybe you didn't read about that impact the way that the judiciary is administered. One of those is just titled, I think it's just Judiciary Amendments or Judiciary Modifications. House Bill 366 and impacts the judiciary in a number of ways. It has an alternative establishment for a constitutional court that only comes into play under certain circumstances. It also impacts the way that certain case assignments are made when those assignments involve a municipal calendar. And that as well is going to have some really significant impact on judicial resources. That kind of gets into the weeds of administration of the judiciary in new ways, ways that we still have to figure out exactly how to make those assignments and how that will impact bandwidth and availability of judge for other kinds of cases. So those are 2 examples of many of ways that bills can impact the judiciary, both in terms of direct impact, perhaps on judges, the way cases are handled, and the way the administrative aspects of the judiciary are addressed.
Thank you. And I bet there's a little bit of construction going on in a few places.
We are knocking down walls and building up new walls. Yes, making room for new justices and court of appeals and for district courts as well. And then there is some figurative construction going on as well as we look at these new assignments that we are to give.
Thank you. Justice Petersen, let me circle back to you again. Some people have complained that the courts, and in particular the Supreme Court, do not have adequate checks on their power because ultimately you kind of get the last word on a lot of issues. If you speak to some of our legislators, and we have, they will tell you that they are exercising their constitutional responsibility to provide a meaningful check on the judicial branch, and they're actually very passionate about it. What are the appropriate checks on the judicial branch, and what does a proper balance of power look like to you?
Well, in the Federalist Papers that were arguments in favor of the United States Constitution, when they talked about the judicial branch They called us the least dangerous branch. And it is because of the three branches, we are three co-equal branches, but we have different powers and responsibilities. The executive branch has the power of the sword. They enforce the laws. The legislative branch has the power of the purse. They disperse the public funds. They set policy. They pass the laws. The judiciary, our power is more of an assignment. We are to interpret the law as it is. We are to apply it in cases and controversies. And we have the power of judicial review, meaning that with respect to the other branches, we are the ones that if someone brings a case to us and says one of the other branches has gone beyond the Constitution, it is up to us to interpret the Constitution and say, yes, you're right, or no, you're not right. So we're supposed to do that with respect to the other branches who have the power of the sword and the power of the purse. We are the ones who are charged in some cases with saying you've gone beyond the bounds of the Constitution. And that's not us acting outside the bounds of our role. That is not us being activists. That is the responsibility we are given. A big part of it under the federal Constitution and the state Constitution, that's our core job. And we don't have that responsibility just for our own enjoyment. It's really for the people it's the citizens of the state. So we are the ones who are charged with hearing controversies where an individual person can come to court and say, the governor, the executive branch violated my rights. And we have to be able to look at that fairly, treat a private citizen on the same footing with the executive branch, and decide that based purely on the law, not because we're afraid that the executive branch will stop enforcing court orders, not because we want to get favor with the executive branch, but based solely on the law, treating them no differently, no better, no worse than a private citizen. We have to do the same thing with the legislature. And when they are a party in litigation, and think about this, think about the checks and the influence that the legislative branch has over the judiciary here in this state. We rely on our funding from the legislature. They set our budget every year. The legislature has a lot of influence over the judicial selection process. The legislature passed a law taking away our ability to choose our own Chief Justice of the Utah Supreme Court. The judiciary, the Supreme Court exercised that. The legislature passed a law giving that to the governor and themselves. They have a lot of influence and power over us. All we have is that we decide controversies when they are a party to litigation, and we sometimes have to tell them, no, you can't do that. We don't have a lot of ways to defend our independence as the judicial branch. We have a big responsibility and not a lot of shields or ways to defend it. Really, all we have is the power of persuasion and the hope that the other branches recognize the importance of having an independent judiciary and respect what our role is in that process. But I want people to understand, I think lawyers understand this, but I want people to understand the reason it's important for the judiciary to be independent and to perform our function of deciding cases based solely on the law without fear or favor toward any party is if you are a person who comes to court to have your rights vindicated, you want to know that you are getting a fair shake. You want to know that you are being treated by the judge as on equal footing with whoever is on the other side of your case, even if it's the legislature who controls our budget. Even if it's the legislature who confirms our next Supreme Court justice, even if it's the governor who we rely on to enforce some of our orders. And if the other branches begin to wield more and more control over the judiciary, can you feel confident of that? And it's our solemn duty to do that job, to decide cases only based on the law. And that's not activism. That is our solemn role. And that's something that I and every other judge in the state is committed to doing, even though we are the least dangerous branch and we have the fewest ways to protect ourselves. We are committed to doing that, and we'll absolutely continue.
Let me follow up on that just a little bit. I'd like to ask you your view, Justice Petersen. What is the state of judicial independence in the state of Utah? Let me contextualize this a little bit. I think, as everybody knows, not only did the Supreme Court get an explicit censure from the legislature, but one particular judge in our state received an explicit censure this last session. There have been calls to impeach a certain judge. And some people have cried out that the judges of Utah don't always reflect the values of the people of Utah. And after all, it's too easy to get rid of you, or too hard to get rid of you. In your view, what is the state of judicial independence in the state of Utah? And I'm going to add a two-part question to this. How do you as a justice and how do judges maintain your independence in the midst of all this public outcry and emotion? I mean, you're a human. And so how do you deal with that?
I confirm I am.
How do you deal with that personally? So state of judicial independence in our state and how you deal with it personally.
Well, it's a bit of a rocky time right now, because I don't think in the past we've seen things like elected officials saying a judge should be impeached. I don't know if the legislature before has condemned individual judges in the Supreme Court. So it's definitely a time of heightened emotions. But I'd say a few things about this. So first of all, to the question of, what if the judiciary isn't, are we expressing the values of the population? You have to remember our role. So we're not creating the laws and we're not creating policy. We are just interpreting the law that already exists. And I would say part of the premise of the last question was that the Supreme Court has the last word, right? And there's no one to check us. That's actually not the case in Utah. It's very hard to amend the US Constitution, but it's not that hard to amend the Utah Constitution. We see amendments that pass, almost every election cycle that are on the ballot. In Utah, the people can vote to amend the Constitution. So they can't put that on the ballot like they can initiatives. Before they can amend the Constitution, the legislature has to propose the constitutional amendment, but then it is the people who have to ratify that to amend our Constitution. So if the people of Utah disagree with our holding in the Supreme Court opinion interpreting Article 1, Section 2 about the people's right to alter or reform their government, if the people decided we don't want constitutional protection for laws that we pass through the initiative power that reform the government, we do want the legislature to be able to repeal those initiatives. The people could change that. The legislature could propose an amendment. The people could amend that provision. They could amend the initiative provision and make it say they could say explicitly, the legislature can repeal any initiative that we pass, even if it reforms the government. The people could get rid of the initiative power altogether. They could decide we only want our representatives representing us. We don't want to do direct initiatives anymore. And they could, if the legislature, assuming the legislature proposed that constitutional amendment, the people could vote for that. So we interpret the law to the best of our ability based on what is there. We're not setting new policy. And if we interpret a statute in a way the legislature doesn't like, they can amend the statute. If the people don't like that opinion, they can absolutely amend it. And then next time around, we will interpret what is there at that point. So we're not actually the last word. There was another part of your question, and
How do you personally handle
yeah.
the impact on your independence?
So first of all, I'm committed to just interpreting the law. I could not do this job if I felt that I had to play favorite to any party before us or fear any party before us. So I don't know any other way to do this job than to just interpret the law as it is. And I do my best to do that. I'm not out to poke the legislature in the eye or seek retribution against them. I'm really not. None of my colleagues are. I think it's the only way any of us know to do the job, is to just interpret the law as it is. And the only thing that frustrates me is that we can't really speak for ourselves usually. We're not out in the public debates. And so when I know we've written an opinion and we've tried to really carefully explain exactly what our holding is, and then I hear people debating about it and I think, oh, that's not what we said. That's not what we said. That can get frustrating. But can I address one other thing about the public debate? So I see in the news kind of a characterization of what's going on with the judiciary and the legislature as tensions between the judiciary and the legislature. And from the side of the judiciary, I just want to say, none of us are doing anything to try to act out against the legislature in any of our decisions. We have a lot of cases where the legislature is a party in a case, and we have to treat them the same as any party who comes before us in a case. We don't treat them better, but we don't treat them worse. If the law is in their favor, they will prevail in the case. There are many cases that come to us where someone challenges a law and says it's unconstitutional. And we say, no, that's constitutional. They can do that. We have a lot of cases where we decide that. And so while I have been disappointed in some of the legislation and some of the statements, and I've been concerned about the erosion of our independence and making statements that might make the public, that we can't respond to, that may cause the public to lose confidence in us, that concerns me. I'm not doing anything in my job that doesn't treat the legislature with fairness and respect when they are a party in the case. The law should be applied to them equally also.
Thank you. Lots of follow-up questions, but we're going to move on. Mr. Gordon, how can you explain to us, how do the courts interact with the legislature? Who decides what to request, how it's pursued? How does that all work? And what lessons have you learned in working with the legislature during the various legislative sessions?
Sure. So I mentioned earlier that the Utah Constitution creates two governing bodies of the judiciary, the Supreme Court and the Judicial Council. And as a staff person, I take my direction from those two governing bodies. So that's important to understand, that it's those two governing bodies that are making decisions about how we as a branch of government are governed, and make decisions about what it means, for example, for us to have an independent judiciary. So I don't take independent decisions on what I think any piece of legislation makes. The Supreme Court might discuss that. The Judicial Council might discuss that. And then they might direct either myself or members of my staff to share with the legislature how we feel about that. So that's going to be one of the primary ways that the judiciary interacts with the legislature, particularly during a legislative session. The Judicial Council has a body that meets every week that takes positions on behalf of the Judicial Council about legislation, that directs myself and other members of my staff to provide feedback to the legislature. And I will note that most of the time, it actually works quite well. So there were way more instances, for example, in this past legislative session, of us as staff interacting with legislators on behalf of the Judicial Council and sharing concerns, feedback that we had, and legislators listening to that and responding to that and making changes that actually were very consistent with what we were hoping they would do. It works the way that we hope it would work quite often. Sometimes it doesn't. The instances where I would say somebody should be concerned are not just where the legislature has a difference of opinion. That's okay. They get to have a difference of opinion. And frankly, if a judge makes a decision about interpreting a law and the legislature doesn't like the way it was interpreted, okay, they can change that. And here's something that sometimes people might not believe, and that doesn't hurt our feelings, right? That is okay. That is the prerogative of the legislature. If it is a difference of opinion about how it should be interpreted or about what the legislature did mean, that is okay. Doesn't hurt our feelings. Where maybe you ought to be concerned is if it looks like an effort is intended to do something different than just make a policy change, but influence the independence of the judiciary. And I can tell you what the Judicial Council means by that is if something looks like it is intended to make a judge ask themselves anything other than what does the law require me to do in this situation, if that's what a bill or a policy or any discussion might be intended to do, then you ought to be concerned. Because that's the judge's commitment. You know these things. I have a little bit different perspective than some maybe on this because I worked for Governor Herbert for every day that he was governor, and he appointed 107 judges, and he asked every single one of those individuals what they thought it meant to be a judge, and they had to provide an answer at least that was satisfactory to him. They had to explain what they thought the role of a judge was, and they had to promise him that they would not only make the easy decisions, but they would make the hard decisions. So where anybody ought to be concerned is if it sounds like a judge might be encouraged or tempted to ask themselves anything other than what does the law require of me in this particular case? And I was in the room when 107 people told at least Governor Herbert what they thought and promised that governor that they would make the hard decisions as well as the easy decisions. I work for the judiciary. Maybe it's easy for me to say this, but I'll tell you, I'm proud to work for a judiciary that makes the hard decisions as well as the easy decisions. I've digressed a little bit. So there are ways that we interact with the other branches of government, legislature, and with the executive branch. And a lot of times it works really well. I don't want to overlook that. The times when it doesn't are probably those when it looks like someone is not just disagreeing with a policy, but is either not understanding or is mad about the very reason that we as a judiciary exist.
Thank you. Justice Petersen, certain members of the legislature have been critical of your court, or it's not your court, but the Utah Supreme Court for not issuing enough decisions and for not issuing enough dissenting opinions. the law's not easy, it's complex, it's not clear. Why don't we have more dissenting opinions? Would you like to address the volume of cases and the perceived lack of enough dissents?
Sure. The first question, during COVID, there was a period where there were no trials in the district court, which backed up all of the litigation in the district court, because as the lawyers watching this know, sometimes you need that trial date to push you to resolve a case. A lot of cases are settled on the courthouse steps. And so there was a backlog that was created in the district court that started at the beginning of the COVID pandemic. That the effect of that and the slowdown there was felt later by the Court of Appeals and then even later by us. So the pipeline of cases coming to us was impacted by the COVID pandemic. And we also had a turnover of 2 of our justices retired at about the same time. And so we had a big transition period. So we had a year where our opinion numbers were lower. And it has steadily improved since then. So that was about 3 years ago. It was atypical. And, where last year we had back to about our normal. We think that somewhere above 60 cases, 60 opinions is about right for our Supreme Court. We're looking for cases that have questions, legal questions where there's not a clear answer. That's what we're looking for, so we can resolve those questions. And then that helps the Court of Appeals and the district courts who are struggling with those questions. Now you've got a clear answer, and it straightens it out for everyone. That's what we're looking for. They're a little harder because there's not a clear answer. And so we really try to think about them and create a rule that is easy to apply and clear for the district courts. So we really think carefully about it. You don't want rushed Supreme Court opinions that just create a mess instead of cleaning up a question. So we were already back to that last year. So I think these were atypical things. And frankly, in my whole career, all lawyers work hard. The people on the Utah Supreme Court with me work harder than they work just as hard as anyone. And so this is not, no one is up there trying to, just relaxing and not working really hard. So I would say that. And the second part of your question?
Well, the second part was number of dissents. So number of opinions and number of dissents.
So this is an interesting criticism to me, because when I first started on the court, we were criticized for too many dissents and too many separate opinions. So, look, if we all agree, we don't have a dissent. And it's frankly just a function of whether someone actually disagrees with the opinion. One thing we do try to do is when one of us is assigned to author an opinion, we circulate it to the other members and they give feedback. And it's like the hardest writing teacher that you ever had, because they go deep and they make all these substantive critiques and they say, I don't agree with how you're saying this. So in that sense, we get a lot of pushback in the process. I get a lot of comments from my colleagues saying, I don't like how you said this, or I don't agree with this. Would you be willing to only go this far? And we really take seriously having an open mind to those comments. And if I disagree, I won't do it. But if I can agree, I would rather have an opinion that all 5 minds on the Supreme Court agree with than just cut it off and say, nope, I won't do that. And then we end up with separate opinions or dissents. So it's actually, I think we end up with stronger opinions that are the result of some compromise, but compromise that we all agree with. And I think we end up with better opinions that way. I'm not sure, maybe they will get their wish and have more dissents if we have 7 people, because now we have 2 more people. We have 7 cooks in the kitchen instead of 5. We'll see what happens. I don't know, but I really am committed to listening to my colleagues, and where I can agree and come up with a decision that everyone is on board with. I think there is a lot of value in that.
You kind of addressed how having 7 justices might impact the court one way or another. Let me ask you this. How will having the governor and the legislature confirm or choose the chief justice change or impact the court? I mean, I hear that, I'm like, okay, what's the big deal? So what's the big deal?
Well, so here's the big deal. When you think about judicial independence, think about this. So now in our state, instead of the Supreme Court picking its own justice, its own chief justice, the chief justice is the head of the Supreme Court and also the chief administrator of the entire judiciary. So the chief justice is sort of like the chairman of the board of the Judicial Council. And our chief justice has been so, his voice has been so important in defense of the judiciary. He has gone to the legislature, delivered a letter to the legislature, spoken with House and Senate leadership on behalf of the judiciary, and has expressed the importance of our independence. Now, the executive branch and the legislative branch are choosing the head of the judicial branch. And I like that the same amount as members of the House would like it if the judiciary picked the Speaker of the House, and members of the state Senate would like it if we picked their Senate president. That's how much I like it.
The chief is also my direct supervisor, so it's a big deal to me. That person is my
Right.
boss.
And so I describe Ron as sort of the CEO of the courts. So he is he's our chief administrator. He's our CEO, and the chief justice is like the chairman of the board. So now our chairman of the board is picked by the 2 other branches of government who already enforce our judgments, fund us, pass laws related to how we're selected, pass laws related to how we're retained. The other branches have a lot of control over the judiciary, and this added element of control, in picking our leader, I worry about it.
Have there been any recent changes to the judicial selection process? What are they, and how do you anticipate that will impact the court's independence, public confidence, those sorts of things?
The changes to the selection process are something that is really, just really concerns me. So when I went through the selection process, the first time I did was in 2015 when I applied for the 3rd District Court. And I wasn't thinking of applying to be a judge at the time. I was encouraged to apply by a couple of friends. And my first thought was, there's no way I'll be selected to be a judge, because I guess I had a cynical view that it must be sort of pulling strings and backroom decisions. And I did not have anyone to pull any strings or do anything like that. And so I thought, this must be kind of a political process. I'm not going to get selected for that. And they assured me, no. In Utah, we have a merit-based selection process. And all you have to do, you can apply. The process is hard. It's a very rigorous process, but you will just be judged on your merits. So I thought, okay, I'll give it a try. And I was so pleasantly surprised when I went through the process that was true. I got selected twice by Governor Herbert for the district court and then for the Supreme Court. No one was pulling any strings for me. Governor Herbert, I wasn't his buddy. that he was picking because he knew me. He didn't really know me. He knew me through the selection process, and he picked me to be on the Utah Supreme Court because I guess he thought of the candidates at the time, I was the best one for the job. And that was profound. That was a profound experience. That is, I would tell people that story. I would tell when I was having juries and stuff, I would tell them, you should know how judges are selected in this state. It is a merit-based process. Utahns should know that that's how your judiciary is selected. And there have been changes to that I am very concerned about. So the first one, our Constitution says judges should be selected based on their fitness for office, their merit, and not for any political consideration. That's in our state constitution. You need structures to uphold that because otherwise politics will just play into it, right? That is human nature. You need structures to make sure it is completely nonpartisan and merit-based. And one of those structures was that our nominating commissions, you apply to be a judge, your application goes to a nominating commission, they vet you, they send questionnaires out to lawyers who have practiced against you to see if you have integrity and the right temperament. They look through all of the information about you, they interview you, and then they select finalists to go to the governor. And that nominating commission, there used to be a law saying that commission could not have, I think there's always an odd number on the commission, could not have a majority of people who are affiliated with the same political party. And that was just to make sure it didn't become political. That's gone now. That guardrail is gone. And that's a big loss. I think Governor Cox is still committed to picking people based on their merit. So this is not a criticism of judges who have been selected under this, but I worry going into the future. You know, that was a structure that needed to stand the test of time to make sure that in years to come, no matter who is our governor and what their intentions are, judges are selected based on their merit. That has been changed. There were some proposals in the legislature that did not pass that would have eroded our merit-based selection process even more. One of them was proposing a constitutional amendment to entirely get rid of the nominating commission or making it optional. So a future governor could just pick their buddy who didn't even go through the nomination process. That's not good for Utahns. That is not the kind of judiciary you want. There have also been bills floated to make judges elected. Right now, the information that voters get is objective information from the Judicial Performance Evaluation Commission on what the people who appear in front of us say about how our knowledge of the law, our temperament, were we fair? This information is all available. If we went to an election system, the information you would get are political ads and billboards and people contributing to judges' campaigns. Would you like to go to court and know that the other side, that lawyer, contributed money to the judge who's supposed to decide your case? I would not want that. So these things are being floated, and they would only harm our independent judiciary. They would erode our merit-based selection process. And this is something that I don't know that the average Utahn really knows how judges are selected and why it's such a good process, but they will be the one to feel the effects if we don't have judges selected based on merit. And so it's something that I think lawyers, if these proposals come out again, that lawyers really have an obligation, like tell your neighbors what they would be losing.
Well, believe it or not, we're at time. if you'll indulge me just a couple more minutes, I'd love to hear any closing remarks that you have. Is what's going right? Is there a call to action? Is there anything good in the world? If not, tell us more of what's bad. But Mr. Gordon, would you wrap it up for us? What are your thoughts?
Sure. Well, I've told you a little bit about some of the things that I think are going right, and there are instances where we have interactions with other branches of government that are positive and should give you a lot of comfort. I've told you that I think you should be proud. I certainly am, to have a judiciary that's willing to make hard decisions and not just the easy decisions. And I mean that. Our judges are smart people. They don't get where they are without being smart people. So there's not a judge who's made a decision that has been controversial and surprised them, right? They know that. And they make the hard decisions because they are committed to the rule of law. That's what you want. As lawyers, that's what you want. Judges who will make decisions based on the rule of law, who are committed to the rule of law, who don't want the job of members of other branches of government, but want their job. And I'm really proud to work for judges who do exactly that. So yes, there are a lot of things to be happy about, to be encouraged about. And if you see things that concern you, speak up. There are some instances where we can speak up, and we do. And there are some times when we can't. So if there are instances where you think the independence of the judiciary is being threatened, speak up. There aren't a whole lot of people who will do that. There aren't a whole lot of people perhaps who are really attuned to that. It impacts everybody. It impacts you perhaps more than some. Look out for those. Speak up.
Thank you.
So I think that one of the things that is going well is that, as is almost always the case, when you read about something like, oh, there's a tension between the legislature and the judiciary, there are a lot of bright spots, and things are not as bad as they may seem, that don't get reported. And so what I wanted to say is, so I'm on the Judicial Council, and I'm on a committee where we track all the legislation. It's called the Liaison Committee. We track all the legislation. And so many times this year, the judiciary would bring feedback to legislators and say, hey, we think with this bill, this could be some unintended consequences, or we oppose this part of it. We only do that with bills that directly affect the judiciary, not policy. And in many times, and Ron mentioned this, they listened to us, they worked with us. So it was a healthy dialogue, and we worked together. We also, even though the judiciary, we have the legislature as a party in litigation often, and obviously we can't talk to them about ongoing cases, we also are both branches of government. And in that way, the courts have made efforts to try to meet with legislators, be available to meet with them, so that when we talk, we can remember, look, these are people, we are people, we can interact with each other in good faith. And I think the more that you interact with each other face to face, the better your relationships can be. And you can remember that, oh, that's another person who's also trying to just do their job in good faith. And so we've done that. The Supreme Court went up, we held oral argument at the Capitol. We had a sort of a reception beforehand, and many legislators came by. I really enjoyed meeting with them. They were very open and happy to talk to us. And it was we had really good conversations. And so I want people to know that it isn't just, we're not butting heads all the time, that they were good people who came and talked to us, and we had really really good conversations with them. So there's that. We also, as a court system, we took a suggestion that first came from the legislature. The legislature said, well, you're not accountable to the people. You don't know what the people want. And again, we're not passing policy. So our relationship with the general public is in our role of, hey, we're the place. If you have a dispute and you need to come to court, here's where you come and we'll interpret the law as it is. But we thought, the court system is kind of a mystery to a lot of people, and we're there for the people of the state. We should open up the courts and let people meet our judges so we don't seem like this mysterious building that they wonder what's going on in there. So we've started this Court Connect project where in courthouses around the state, judges, we advertise it, people come and meet with the judges and just answer questions about how things in the judiciary work. And a lot of them have been really well attended. You might be surprised that some people want to spend an evening talking to judges about how courts work. But we've had good attendance. So I think that's a great move by the judiciary. And that was us listening to a concern of the legislature. And we responded to that and tried to think of a way, how can we address that? And can I say one last thing?
Of course.
Okay. This is about the judiciary and the role of lawyers in the judiciary that I want us to think about, because we're all celebrating this year the 250th anniversary of the Declaration of Independence, which I would encourage you all to reread. We learned the preamble in elementary school. I remember memorizing it, but we don't often sit down and read all of the Declaration of Independence, and it is an awesome read. It is inspiring. So I encourage you to read it. And so really what the Declaration of Independence was the Second Continental Congress explaining why the colonies were going to revolt against the king. And there's this very inspirational preamble, but the next section is all of the complaints against the king, because the colonies wanted to explain to the world, here's why we're doing this and we're justified in doing it. So there's a whole list of grievances against the king. And a lot of them relate to the fundamental role of the judiciary and the denial of that to the colonists. So let me read, we're getting into the complaints against the king. So the Declaration says, the history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world. And then we go down, and here are some that are specifically about the importance of a judiciary. He has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers. He has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. He has quartered large bodies of armed troops among us and protected them by a mock trial from punishment for any murders which they should commit on the inhabitants of these states. And he has deprived us in many cases of the benefits of trial by jury. This was 1776. This was our founding generation calling out how important it is to have this role of the judiciary, an independent judiciary who is not dependent on the will of the executive or any other branch, so that cases can be tried based on established facts and the established law. And as lawyers, we know deep down the importance of that. And one great thing that I want to say is I have been so impressed and so heartened by the number of lawyers who understand this. And when you've been concerned that there are laws that would impact the independence of your judiciary, you have stood up and said so. I can't tell you how much I appreciate that. I appreciate your willingness to do it, and I appreciate your wisdom and your understanding of these fundamental principles that animated our Declaration of Independence, our U.S. Constitution, and our Utah Constitution. So I want to thank you. You are a bright spot.
Well, thank you. I'm going to take a 30-second personal privilege as we draw a conclusion. Today is Tuesday, March 17th. It is caucus night. And as I've heard these panelists speak, I've felt an important stewardship as a lawyer to protect the judiciary, speak out for the judiciary. The most important vote you can cast in all of the election cycle is tonight at your neighborhood caucus meeting. On the screen is a link where you can find information about your preferred party, and you can learn about where the meetings are. My call to action is for you to go get involved in your neighborhood caucus. So that's my call to action. It's tradition at the end of a program like this to thank the panelists and give them a round of applause, but words can't express how genuinely thankful I am for your participation here. This is an important conversation. I feel passionately about it. I know you feel passionately about it. I am so grateful for you both to come here and let your views be heard, help us to understand your views better. Let us all go forth and protect our courts and the judiciary. Thank you. I didn't get to ask you about it.
It is also a tradition for the next talk sessions to close with your last.
Oh, yeah. Absolutely.